welcome everybody to this All Access Nonprofit Roundtable. Um, we provide these generally for our nonprofit users. So if I see at least a few of our lawyer friends on the call, but to the non-lawyers who are actually nonprofit leaders, don't worry, this is mostly geared at you, and the lawyers are just observing here. So this is mostly for you. One practical note as we get going on this, I'm going to keep the introductions brief, but it is helpful if you have questions on any of the material being presented, if you drop it in the chat or the Q&A function here in the webinar as soon as you have it, it's helpful to me if I can see a queue because I know if we have, 10 questions in the queue, then I won't start with my own questions during the Q&A half of the event. But if nobody asks questions, then I will fill the void. So feel free to put them in as they come. And with that, just happy to introduce Gabriella Anastasiopoulou. Gabriella is a seasoned attorney with a lot of pretty impressive experience in the world of conscience rights, religious liberty, civil rights in various departments within the federal government. She's done some really cool work, and she's here to talk to you all about conscience rights, and particularly as it relates to religion and the work of nonprofit organizations. So, Gabriella, thanks for being here, and I'll turn it over to you.
Well, thanks, Frank, for the invite. It's an absolute joy to be on here talking about a subject I really care a lot about. Do we want to go ahead and get the slides up? Right now, I don't see them, but let me know. I'll keep talking till they're up. Like Frank said, I worked for about 10 years in the context of conscience and religion at the Department of Health and Human Services in their Office for Civil Rights, which is where a lot of my experience comes from for this webinar. I am no longer employed there. I now work for a different government agency, but all of the views stated on this webinar are my own and should not be imputed to my employer in any way or former employer. But it's a subject I care a lot about. I loved absolutely spending those almost 9 years at OCR learning about these statutes, and it's a big passion of mine to make sure that people are aware of them. They're part of the cultural conversation, and people are aware of what resources are out there to help them when it comes to enforcing these statutes. So do we see the slides?
Sorry, I can see them. I
You can see
assume,
them?
that- yeah.
Okay, does anyone want to throw in the chat if they can see them or not to just make sure?
Yeah, Zoom is being a little funny today. The chat is quiet.
I do see it when I minimize the screen. Okay, I think they're on.
Okay.
Hearing no complaints, I see the Q&A is bubbling up, so maybe it's someone wrote in the Q&A there, Frank. So we're going to talk about today conscience and religion rights of organizations participating in federal programs. An incredibly creative title, incredibly long. If anyone has any ideas for how to shorten this and make it more interesting, feel free to send it in. But we're specifically going to be talking about federally enforced statutes. Next slide. So what exactly are we talking about today? It's going to be federal financial assistance. That's going to be the big hook that makes all of these statutes relevant to you guys, or whether you are the ones actually receiving federal financial assistance and then therefore have certain obligations or protections associated with the receipt of that federal financial assistance, or if you're interacting with another entity that is a recipient of federal financial assistance and then therefore might have obligations due to the fact that they've received that financial assistance. So we'll talk a little bit about what that is and what it means. We're also going to talk about the statutes themselves. There's conscience statutes and then there's religion statutes. The conscience statutes are a little bit different, even though some of them mention the term religion. They're largely anti-coercion statutes designed primarily to prevent federal government coercion in federal programs, whether it's by the government itself or an entity receiving federal money in order to help run a program, to prevent the federal government or federal programs from coercing individuals to participate in certain procedures to which they have a moral or religious objection, like abortion, euthanasia, and there's other examples as well. And we'll talk about our religion statutes too. These are going to be more akin to your traditional civil rights laws. They're going to be, in this program, don't discriminate on the basis of religion. Some of you might be familiar with Title VI. Title VI, of course, deals with race, color, national origin. It prohibits discrimination in federally funded programs, but it's all federal monies. It's really broad and it's where it touches. You'll see with the religion statutes, there's so many of them because they are specific to particular programs. There's not an overarching don't discriminate on the basis of religion in all federal programs type statutes. So instead, you've got a bunch. But in total, between the conscience statutes and the religion statutes, there are over 50 different provisions and regulations that are involved. So we're not going to go through every single one of those. That would take multiple webinars to get through. But I want to just give you some broad familiarity with the ones that are probably going to be most relevant to religious nonprofits, religious organizations, and otherwise more of an overview of the statutes. And then, of course, like I mentioned at the beginning, more information about OCR, who they are, what they do, and some of the resources that are available. Next slide. So first, federal financial assistance. We'll go ahead to the next slide. So distinct from being a beneficiary under a federal program, so you think the beneficiary would be the ultimate individual that the federal program is trying to support. So you have the person who's the beneficiary, who they could be receiving money, but they're not going to be considered a recipient of federal financial assistance under these statutes. Where being the recipient comes in is when you're receiving the monetary or non-monetary award in order to conduct some type of program for the benefit of the beneficiaries. So we're focusing on recipients of federal financial assistance as being those entities who are getting those federal dollars in order to carry out programs that support a beneficiary. And I want to make that distinction because being a recipient of federal financial assistance as a beneficiary does not create obligations for you under these statutes. It's the obligations go with who the recipients are. So federal financial assistance can take multiple forms. Like I said, it can be monetary or non-monetary. Monetary is going to be the most straightforward, an award or a grant of money. When you apply for a federal grant of any sort, of which there are innumerable amounts, all sorts of different programs that they cover, it comes in a dollar amount that gets dispersed to you in order to conduct the program under certain parameters. But it can also take non-monetary forms, including renting federal land, property below fair market value, training programs, loaning of federal personnel, and other arrangements. But under certain civil rights statutes, for example, Title IX, it typically doesn't include contracts of guarantee or insurance by the federal government. But nonetheless, the definition of what is federal financial assistance for a certain program can vary depending on applicable executive orders, regulations, and case law. So this is just a flag for people to be aware of, that it's generally going to be any sort of benefit that you can get from the federal government, monetary or non-monetary, in the context of conducting a federal program, or just receiving dollars to help your program. But the definition can vary a little bit depending on which program we're talking about. Next slide. The main thing to think about, though, to contextualize what the relationship between your organization and the federal government is when you decide to receive federal financial assistance, is that it's a contract. This concept comes from this 1981 case that actually dealt with an institution for those with mental disabilities. And in this case, it was the state of Pennsylvania that ran this school called Pennhurst State School and Hospital. And they had some individuals who were inside of the institution who filed suit over their treatment because under the Developmentally Disabled Assistance and Bill of Rights Act, which was the program that was funding Pennsylvania, that Pennsylvania was using to help run this school, said that patients had a Bill of Rights where they had a right to appropriate treatment services and habilitation in a setting that's least restrictive of their personal liberty. So they were filing suit over this issue. And this is a good example of how the fact that Pennsylvania got federal dollars, a third party was trying to enforce their rights under the federal program by suing that party that was the recipient of the dollars, in this case, the state Pennsylvania. And this kind of situation is also helpful to pay attention to because, like I mentioned at the beginning, even if you yourself are not a recipient of federal financial assistance, there may be instances where an entity like a state is getting federal dollars. That creates certain obligations on their part with how they're supposed to treat entities that they're working with in other capacities. And you'll see some of the conscience statutes create protections in that type of context as well. Next slide. So let's take a look at the statutes themselves. Next slide. We'll start with conscience. And surprise, surprise, a lot of the current history with conscience statutes that are enforced, especially at the Department of Health and Human Services, at their Office for Civil Rights, started with Roe versus Wade in 1973. Next slide. So in 1973, of course, at the beginning in January, Roe versus Wade is passed. Then later in that year, in a case called Taylor versus St. Vincent's Hospital, a district court issued an injunction requiring a Catholic hospital to provide a tubal ligation to a woman who was scheduled for a C-section delivery. The theory that the Montana District Court put forward in the case was that because St. Vincent's Hospital received federal dollars, then they're acting under the color of state law, and so therefore can be subject to what's called a 1983 claim, which is a statute that allows lawsuits against typically against states or the federal government in order to enforce a constitutional or civil right. So the court was extending that concept by saying, you got the federal money, so then you're acting under the color of state law. So we're going to treat you like you're the state actor here, and you need to provide this sterilization procedure. Congress responds to that situation incredibly efficiently for our days. And in June of that same year, they passed the first provisions of the church amendments. Additional provisions of the church amendments get passed the next year in 1974 as part of the National Research Act. As that particular act was a backlash to the untreated syphilis studies at Tuskegee. And then there's some additional provisions that get passed in 1979. But if you go ahead and go to the next slide, you'll see that there's three different elements to the church amendment. So this first bullet, recipients of Public Health Service Act funds. So that's a particular program. Well, it's the Public Health Service Act created a whole lot of different programs. There's a lot of federal dollars that come underneath the Public Health Service Act. But in response to that Taylor decision, the Congress said that if you are a recipient of these Public Health Service Act funds, that cannot be a reason for a court or a public official to say you have to provide abortion. Effectively, they were countering this idea that just because you received federal dollars, you're acting under the color of state law and have to provide services as if you were the state themselves. So that first piece was in direct to overrule directly that district court decision. The next piece is about prohibiting entities that receive certain federal financial assistance from discriminating against individuals. So again, like we were talking about earlier, there are contexts in which your organization might not be the one receiving federal dollars, but another entity that receives the federal dollars has an obligation not to discriminate against you. This particular provisions largely deal with individual providers. You see physicians, healthcare personnel, or other individuals who object to abortion, sterilization, or other lawful health services or research activities. So an entity that's receiving those federal dollars has an obligation not to discriminate against these individuals on these bases. The very last provision, protecting applicants for training or study who object to abortion or sterilization. That was the one that was added in 1979. I think that's Church E. But again, it's specific to an individual, and it talks about if you receive federal financial assistance, you can't discriminate against an individual on that basis. So, in the context of Roe, in the context of a district court attempting to require a Catholic hospital, which of course is trying to follow the ethical and religious directives where they're not allowed to provide sterilizations or abortions at the hospital in keeping with Catholic teaching, Congress is directly responding to this circumstance and saying, federal programs, we are not going to coerce anybody that gets federal dollars or that's inside of a program that gets federal dollars to have to provide these procedures to which they have a conscience objection. That lawful health services or research activities language that's a little broader and not specific to abortion sterilization, that's the language that came in response to the Tuskegee syphilis study. And essentially, Congress was attempting to encourage individuals to be whistleblowers, to speak out when they see something unethical happening, something to which they have a moral disagreement, to hopefully prevent that kind of situation from happening again. Next slide. Another one of our big conscience statutes is the Coates-Snowe Amendment, came in 1996. So church amendments, like I said, you have 1973. Conscience, of course, the idea of conscience has a long history in our country, going back to the founding conscientious objectors to wartime. But you see this healthcare context, protections for conscience coming up in the context of abortion. 1973 church amendments, and then later here in 1996, the Coates-Snowe Amendment. This Congress passed these amendments in response to ACGME, which is the accreditation body for medical education, passing requirements that OB-GYN programs had to provide abortion training to all of the, anyone who attended an OB-GYN program was going to be required as part of the curriculum to have training in induced abortion. And the model specifically was going to be an opt-out option. So the standard curriculum is you provide abortion as part of you get training on abortion, learning how to do it. If you have a specific moral objection, you can request to opt out from that part of the curriculum. And that was a shift from a prior model where you could or could not provide abortion training in your program, depending on if someone opted into it. So if someone had to affirmatively say, I want the abortion training, then you had to deal with addressing that situation. And you can see we flipped to a more friendly approach to having abortion, creating higher access to abortion training by requiring that everybody have to go through it. And so then it's a more difficult situation for the individual who wants to opt out and not have to participate in that because they have to affirmatively state they want the opt out. So Coates-Snowe gets passed to basically to clarify that if you are receiving federal financial assistance or you're the federal government, so you're receiving federal financial assistance as a state or local government, then you can't discriminate against a healthcare entity, which is defined in the statute and generally includes a provider and certain other training programs, on the basis that they refuse to undergo abortion training, they refuse to require or provide training in their program, refusing to perform abortions, referrals for the abortions or training, making arrangements for any of those above, or in the case of an individual that they attended or attended an abortion-free training program. Next slide. Our third main conscience statute, and like I said, there's a lot of them. There's around 25 provisions total. So I'm walking through the major provisions that that constitute a lot of the activity that you see in the context of OCR and that have some of the broadest authority. So the Weldon Amendment is an appropriations rider that was first passed in 2004. Because it's an appropriations rider, that means it is attached to the appropriations bill that Congress passes on an annual basis in order to fund the federal government. And it has to be repassed every year with the new appropriations bill that gets passed in order to continue funding the federal government. So it's been passed every year since 2004. And this statute prohibits federal, state, and local government entities that get funds underneath the Appropriations Act from discriminating because the healthcare entity that's the protected party doesn't pay for, or provide coverage of abortions. And you can see here it's also defined specifically in the statute what healthcare entity is. an individual physician, or other healthcare professional, a hospital, provider, sponsor organization. So an example of the enforcement, including the Weldon Amendment, is a good is it's a good example of how you don't need to be the federally funded entity in order to have some protection in this context. So OCR did find some years ago that the state of California had violated the Weldon Amendment when it passed, and the Coates-Snowe Amendment, the one we just talked about before, when it passed the FACT Act, which was a statute that required pro-life pregnancy centers to post notices about where women could get abortion information. The National Institute for Family and Life Advocates sued in federal court under a free speech and First Amendment theory. They did win at the Supreme Court on that case, but OCR also separately found that that action by the state of California, which was the federally funded entity. California, of course, receives probably billions of dollars in money from the Department of Health and Human Services, including money that comes from the annual appropriations acts. And in targeting pro-life pregnancy centers specifically for certain requirements, lest they face punishment about posting about abortion, was that discrimination, targeting those entities on the basis that they don't provide abortion coverage. Next slide. So the Affordable Care Act is the last of sort of the big major conscience statutes we're going to talk about. It's got two different sections that are the most relevant. One is 1553, which is protections for those who oppose providing or assisted suicide. So it prohibits that federal, state, local government or also a healthcare provider or plan that gets federal dollars from discriminating against entities or healthcare providers who don't participate in assisted suicide. And Section 1303 is very similar, but with the context of abortion. And it also specifies that qualified health plans can determine whether or not they want to provide abortion coverage on the exchange. Next slide. So these are just sort of a quick overview of some of the other conscience statutes. Assisted Suicide Funding Restriction Act protects providers who are opposed to counseling for assisted suicide. RNHCIs, religious non-medical healthcare institutions, are an interesting group of institutions. This is our one conscience statute that actually predates the Roe versus Wade, the Roe era. And RNHCIs are typically Christian Science sanatoriums. So individuals who rely on prayer for healing, they're allowed coverage in the Medicare, Medicaid programs in certain contexts. And that's what that series of statutes addressed. And then there's a whole bunch of program specific, like under Medicare and Medicaid, provider and patient protections. A lot of the patient protections you see are what's called a rule of construction. And a rule of construction essentially lays out the way a statute should not be construed or should not be interpreted. So a good example is there's a provision tied to the Garrett Lee Smith Suicide Prevention Program. So that's a program that provides federal dollars to support suicide screening and assessment and prevention. But there's a provision in there that says nothing about the statute or the requirements of this program should be interpreted to require a patient to have to undergo psychiatric screening for suicide assessment if it's against their religious beliefs. So there's a smattering of patient protections in there that are in this conscience statute context as well. Next slide. So, I just went through a whole bunch of statutes with a whole lot of information. There's a lot going on. One thing that's helpful to sort of pull it all together is to be aware of the rulemaking that OCR has done in this context. I'm going to have a link to the website at the very end of this PowerPoint, and you're able to go there to see the website to look more about the look up more information about the rulemaking. It's been a bit of a tumultuous history doing rulemaking in the context of the conscience statutes. But in the spring of last year, OCR announced that they were going to be updating this rulemaking. I think it's the fifth time in the last 9 years or so that it's been updated. But rulemaking is a great example of how religious nonprofits and other entities interested in these issues or individuals interested in these issues can get involved because agencies will, on an annual basis, usually in the spring and the fall, announce their rulemaking plans in what's called the Unified Agenda. So you can see this announcement was from the spring 2025 Unified Agenda. And once those rules are actually published in the Federal Register, then the public, if it's a proposed rule, or it could be just a request for information, or even a final rule with request for comment, these are all opportunities for the public, for you all, to voice your concerns, your opinions on the rulemaking that's being proposed or the action that's being proposed by the agency, and to give context that's specific to you and your situation. The agency has an obligation to review those comments, to respond to comments that are material to the rulemaking. So you'll see in the Federal Register, once it comes out in a proposed rule form, it has a bunch of background information explaining why the rulemaking is happening and then gives the proposed rule text. Then you have the opportunity to comment on that, and you'll see in the final rule, the preamble that's comes before the final rule text will give responses to those comments. And the comments received by the public can have a significant effect on what the agency decides to do, if they decide to make a change or not, or to go forward with rulemaking or not. So I always encourage everyone in the public to take advantage of this. It's a completely accessible way to participate in the federal process, dealing directly with these statutes that can impact you directly. And you don't have to have an attorney or any special knowledge in order to be able to participate in this part of rulemaking. You simply just write in a comment and it will be taken into consideration. Next slide. So after the whirlwind of conscience, we're going to go through the whirlwind of religion. Next slide. The first group, I have them grouped into categories of statutes to help, especially because the groups do have a lot of similarities, and it can help with contextualizing what type of statutes are out there. The first group are the block grants. Now, block grants originated with the 1981 Omnibus Budget Reconciliation Act. You can see listed under there are some of the original block grants. They used to be a smattering of smaller programs, and then Congress grouped those smaller programs into much larger programs called block grants. And block grants typically function as a pot of money that the federal government has allocated for states to apply for that money, and then they have a lot of leeway in how they use that money. It needs to be used for the topic of the block grant, generally speaking, but states have a lot of flexibility in how they use that money. But after the 1981 Omnibus Act created those block grant programs, there were some other ones that were created later. But the language within each of these block grants that prohibit discrimination on the basis of religion is nearly identical for all of them except the Child Care and Development Block Grant. And again, if you're familiar with Title VI or even Title IX, the language of those statutes, the language here in these block grants mirrors nearly word for word those statutes. Congress intended, because like I said at the beginning, there's not an overarching federal statute that prohibits discrimination on the basis of religion in all federally funded programs. Congress did decide nonetheless to extend the Title VI type protection to the context of religion in certain block grant programs. This is again how paying attention to the federal financial assistance piece is crucial to understanding these protections and these authorities and the obligations that come with them, because they're all tied to specific programs. So, if you're getting block grant money, it's going to come with specific religious non-discrimination provisions. If you're getting money under the Public Health Service Act, like we saw earlier in the context of conscience, there are specific conscience protections that apply to that, both in the form of obligations on the federal recipient or the recipient of federal funds to not discriminate against others, and for the protections for those recipients of federal funds, especially in the case of, for example, a religious hospital or religious entity to not be coerced to have to provide certain services against their religious mission. Next slide. The next group we're going to talk about are the charitable choice statutes. They're both statutes and regulations. They have an interesting history because they're, as you can see from the slide, fairly bipartisan in the way they've been handled. It was charitable choice statutes initially passed by Congress were signed into law by Bill Clinton in the 90s. Those original ones attached to these four major programs, TANF, community services block grants, a bunch of substance abuse and prevention treatment programs, and in the context of Department of Labor welfare to work programs. What was significant about charitable choice being passed is the federal government used to have a posture of avoiding funding overtly sectarian institutions, largely out of establishment clause concerns. In the 90s, there was a push and a shift through these charitable choice statutes to say, okay, we can fund religious or sectarian institutions so long as it's not the money that we're giving to them is not used for sectarian worship, instruction, or proselytization specifically. Again, those establishment clause concerns were still there, but it had softened a little bit to at least allow some federal dollars going to religious entities. So these are going to be really crucial for any religious nonprofits who are looking at being involved in federally funded programs to pay attention to these, because this is a body of law specifically developed around how we can make sure religious entities can participate in federal funding without compromising their religious mission. So President Bush expanded what Congress did here with charitable choice provisions and statute. He expanded through executive order, extending the application of this charitable choice concept to all social service programs. President Barack Obama, and President Donald Trump in his first term followed up with additional executive orders. There was a lot of back and forth about what do we call the White House office that was created initially under George Bush's executive order called the White House Office of Faith-Based and Community Initiatives, and other things like that. And there's a lot of disagreement over particulars, which we'll talk about a little bit. But the charitable choice statutes are still in effect. The regulations that were required to be written and published after the Bush executive order are still there, and they're just an important body of law to pay attention and be aware of. Next slide. And we'll flag right here, as you can see, federal financial assistance. That executive order from President Bush has its own definition. So going back to what we talked about in the beginning, federal financial assistance, it's generally any sort of benefit you're getting from the federal government in order to run a program, in order to benefit the public in some way. In the context here of charitable choice, it does cover contracts and loan guarantees. And like we saw in the earlier slide, in the context of Title IX, certain contracts and loan guarantees are not always included in the meaning of federal financial assistance. So it's an important thing to pay attention to when engaging with the federal government, is whether or not your dollars are counting as federal financial assistance in the context of the program in which you're participating, in order to also understand what are the protections, what are the obligations that are going to come in with this. Next slide. Now, I mentioned earlier charitable choice provisions, both the statutes and the regulatory provisions. Well, the statutes, it's just going to cover that entire statutory program, but the regulations refer to charitable choice applying in all social service programs. So what is a social service program? The executive order that was passed by Bush, gives a definition, a program that's administered by the federal government or state or local government using federal financial assistance, providing services directed at reducing poverty, improving opportunities. It's a pretty broad category of services, but we can understand them as being a bit distinct from healthcare services. So the Department of Health and Human Services, this is going to be probably more on the human services side of things. And some examples from the executive order are like childcare services, if you provide transportation services, job training services, information and referral services, any of these types of services that your institution may be providing to beneficiaries to the public that are federally funded. Next slide. So what are some of the provisions in this? Okay, we understand charitable choice is supposed to somehow be helping religious institutions participate in federal dollars or in receiving federal dollars in order to help conduct federal programs. What exactly does it say? First, let's explain what does the choice in charitable choice mean. Part of this establishment clause concern was making sure that entities or that individuals who needed services, like if they needed those transportation services or help with dealing with an alcohol addiction, that they had a meaningful choice in what kind of provider they received services from that was funded by the federal government, because the government did not want to be seen as requiring you that in order to get your addiction help services from the federally funded program, the only option is for you to have this religious provider. Again, this is kind of an older view in the law of concerns about the Establishment Clause. There's been a lot of developments in Establishment Clause jurisprudence of the Supreme Court. So I wouldn't say that's exactly how the Establishment Clause is understood today, but that's the concern that you see echoed in the charitable choice provisions, wanting to create a choice. So there are provisions that guarantee that if you're a beneficiary and you're trying to access a federal program and the provider you get assigned to is a religious provider, the federal government has an obligation to make sure that you get another provider who can provide similar services to you, some kind of alternative secular provider that you don't have an issue with the religious identity. The second provision that's in the charitable choice statutes, again, I said there's a group of statutes and there's a group of regs. The statutes do have a provision that's specific to religious entities that are getting funded under social service programs especially from the Department of Health and Human Services, but also other departments like HUD and Department of Education. So it prohibits religious entities from discriminating against beneficiaries on the basis of religion. As you can probably imagine, just thinking about it off the top of your head, that seems a little bit funny to only say only religious entities can't discriminate on the basis of religion. What about secular entities? So needless to say, the executive order from Bush and the regulations that followed extended this non-discrimination provision to secular entities as well, so that there's a broader prohibition against discrimination on the basis of religion in these federally funded social services programs. Another provision that was introduced in the charitable choice is this concept of indirect versus direct funding. This idea is you can get the money directly. The federal government grants you the award and sends you the money directly, or you can get it indirectly. For example, if the money travels with the beneficiary, so an individual beneficiary gets the money directly, and then they can decide, do I go to this provider or this institution or this service? They have a choice, again, going back to that choice, and that's indirect funding. There's been some legal fights back and forth about what exactly are the implications of getting the money directly versus indirectly. And you'll see in other civil rights contexts, even if you get the money indirectly, you're still bound by civil rights laws, for example, to not discriminate or on the basis of race or sex or what have you. But in the context of charitable choice, there's been a bit of the idea is that if you get the money directly, you might have more obligations with concerns to the Establishment Clause, whereas if you have indirect funding, then those Establishment Clause concerns are not really there. And you saw this issue come up under the regulations passed during the Obama administration. They created notice and referral requirements specific to religious entities to make sure that that choice in bullet 1 was honored. So if you, a religious entity, someone came to you and said, I don't want to receive I need these federally funded services, but I don't want to get them from you because I have an issue with your religious teachings or what have you. Under the Obama regulations, then the religious entity had an obligation to make sure that person found an alternative secular provider. The Obama regulations also said, in the context of indirect funding, the additional requirements under charitable choice that extended with the Establishment Clause concerns weren't going to apply to you. But if there's no other secular alternative in the area, we think the meaningful choice then is ruined. And so we're going to treat you as if you were directly funded and you have more obligations in the context of those Establishment Clause concerns. After the first Trump administration, or during the first Trump administration, Of course, they responded to that by removing those notice and referral requirements that were specific to the religious entities, and instead put that burden back on the federal government, since the statute doesn't say that it has to be the religious entity that does it. And of course, that raises some First Amendment issues with putting a burden on only religious entities and not other entities. So that's been removed. They also removed that interpretation about indirect. You get treated as a direct recipient of federal funds if there's not another secular provider around. So that's again extending more protections for religious entities in the context of preserving their religious mission. And then it also highlighted RFRA obligations, the Religious Freedom Restoration Act obligations of the federal government to provide accommodations. So there's been some back and forth, but that's all just sort of awareness around what the provisions are and what's going on there. Then the last thing to pay attention to, though, is Title VII's exemption for hiring co-religionists is preserved in the context of charitable choice. So even though there's this requirement that if you're receiving federal dollars through social service programs, you can't discriminate on the basis of religion, there's an exception that you can still take religion into account as a religious entity when you're hiring, because of course that's crucial to your mission. Next slide. One of the resources I want to point out, because I'm sure this was just like, there's a lot of information about charitable choice. There's a lot of statutes. There's a lot going on. Statutes, regulations, federal financial assistance. There is somebody to help you with all of this beyond just me in this very short webinar. There's a office called the Center for Faith. Again, the name has changed multiple times with different executive orders, but the executive order said each agency needs to have a liaison with the White House office to basically, and an entity in the agency to be a resource for religious entities, religious institutions, religious nonprofits who want to get involved with federal programs in some way, whether it's through coordination with the federal government or actually becoming a recipient of federal financial assistance. So the Center for Faith at the Department of Health and Human Services is located under the Office of Intergovernmental and External Affairs, IEA. This is their website. As you can see from the side, they have grants information. They have links to these regulations that I was just talking about on charitable choice. They have links for federal resources, contact information. They're a great way, again, to just have a resource for information to understand this whole universe, and also to just express concerns and converse with the federal government about the role of faith-based nonprofits and faith-based providers in the community and the mutual mission of trying to provide appropriate health and human services for the public. And you do not have to be federally funded in order to contact them. You can certainly contact them and ask for resources and information about being federally funded if you'd like to, or again, other ways to interact with federal programs. Next slide. So on top of all of what I just talked about, there are still more religious laws or laws prohibiting discrimination on the basis of religion that are enforced by the Department of Health and Human Services. I'm not going to go into all of them because, again, it's sort of a dizzying number of statutes and laws. But just a quick highlight, there are CMS visitation regulations. We saw these become very prominent during the COVID pandemic, and it was during that time frame that the authority to enforce this specific provision relating to religion was delegated to the Office for Civil Rights. So they're the go-to in this context, and it may be relevant to you all as religious entities to the extent you have a representative or religious leader or minister trying to visit a patient in a hospital. These regulations effectively say visitation policies can't discriminate against patients on the basis of religion. We saw that a bit in COVID, like I said, where you'd see maybe a family member was allowed, but not a pastor or something to that effect. Then there's a whole bunch of other program-specific provisions under Hill-Burton, Head Start, PACE programs. Some of the names of these programs might be familiar to you, but they're going to be specific non-discrimination provisions, either largely attaching to the beneficiaries, the individuals who are being served by those programs, specific to the particular program that's named. Next slide. So I've mentioned OCR multiple times. I'm sure you all can guess the answer to this question now. Who do we call when we need help? Next slide. It is the Office for Civil Rights at the U.S. Department of Health and Human Services. This is their mission statement. I'm going to go ahead and read it to you from the website. As a U.S. Department Health and Human Services law enforcement agency, the Office for Civil Rights ensures compliance with our nation's civil rights, conscience, and religious freedom and health information privacy and security laws by investigating complaints, conducting compliance reviews, requiring corrective and remedial action, promulgating policy and regulations, and providing technical assistance and public education for the American people. It's a lot. They do a lot with a small staff. I loved working there in part because the people were so wonderful, doing a lot with very little. But this is going to be your go-to resource on multiple levels with regards to these statutes. They have a portal, and I've got a link to just the website there on the slide where, well, it's not on this slide, but I told Frank that if anyone wants a copy of the slides, I can send it to you. And I will send the updated version that has the link to OCR's website on it. But you can file a complaint. They have a portal. You can go in there and file a complaint if you believe your rights under any of these statutes have been violated. You can send inquiries to the Office for Civil Rights, letters. You can request technical assistance, like it says in the mission statement, if you need assistance with something, especially if you're a religious institution like a Catholic hospital, or even if you're not a religious entity but want to make sure your policies around employment and religious exemptions and conscience objections are in line with all your statutory obligations. You can go to OCR for technical assistance. Like I said, comment on regulations that OCR puts out about these and other statutes. OCR's general goal is to achieve voluntary compliance. They want to hear from you. They want to hear from the public. Filing a complaint, submitting a comment to a regulation, submitting a letter just addressed to the Office for Civil Rights with any concerns or inquiries you have are ways to communicate with the federal entity that is enforcing these statutes, letting them know what your concerns are, what's happening out there in the regulated community, because that conversation is crucial to the Office for Civil Rights being able to understand and do their job well. So if they want to hear from you, I encourage everyone to do that kind of a interaction with them to the extent you can. Next slide. This is just a screenshot so you guys get a quick glimpse of the website specific to the conscience and religious freedom statutes. Like you can see at the bottom there's two drop downs, one for conscience and one for religion. They expand, they have the whole 9 yards of all the statutes. They also have great links to actions that OCR has taken in the context of enforcing these statutes, regulations that have been drafted, historical information, all sorts of other stuff on there. So I encourage people to go to this website, especially if your head's spinning a little bit from the enormous amount of information that I've just crammed into less than an hour on this webinar. But again, this is a place for resources. And the Office for Civil Rights is the place to go when you think there's an issue with regards to your rights being violated under these statutes. Next slide. I think that's it. I left a little bit of time for some conversation, Frank.
No, thank you so much. This was excellent, and I will definitely be one of the participants who's going to review the slideshow and all the various laws. So I don't see questions in the chat right now. I just want to throw out two quick things related to what you're saying that I think are really important. One, I think of interest for all of our nonprofit attendees and the lawyers who work with nonprofits is, as you said, right, the nexus to make all of these federal regulations apply to you is generally some kind of federal benefit. There have been efforts in recent years to argue that receiving 501c3 status is a government benefit. And if that were a successful argument, that would put every C3 on the hook for all these federal regulations, which is frankly kind of insane. We we submitted a brief at the Fourth Circuit that I think was actually pretty influential when they shot this down in a case called Baltimore Lutheran. They tried it in the Hillsdale case in the Sixth Circuit a couple years ago, and then they withdrew that claim from their appeal. So for now, that seems to be dead, but that's just something to be aware of. It does lurk, and it would be a game changer for nonprofits. And the other thing I would just say is that to support your point that like these offices, especially these offices for faith or centers for faith, they do care about what normal people have to say about these various fields. One of the, not at HHS, but one of the other centers for faith recently reached out to me and to a colleague of mine and just asked like, hey, we're doing work in, I won't say which agency, but we'd really like to know more about what happens on the ground for religious organizations and how we can help improve the landscape for faith. So especially when there's an admin that is ostensibly friendly to religion, but in general, like these offices do care. So to the people listening, if you think, well, I have an idea, but the federal agency for whatever isn't going to listen to me, it's likely not true. They do like to hear from little people like me, so clearly from you guys as well. Um, yeah. Do you want to comment on either of those, or else I can get to.
Yeah, I mean, first about the tax exempt status, I find that one very interesting in part because that Taylor versus St. Vincent Hospital case that we talked about, that was the impetus for the initial church amendments. Part of the rationale was the court was you get a tax break.
Yeah.
And so it's interesting to see that in the context of like the church amendments were passed to directly contradict that thinking. We don't want that. So, like you said, it would be a significant change. I don't think we're going there, especially under the Supreme Court, but it's something to be aware of. And then, yeah, exactly what you said. Even if you don't feel that a particular administration is going to really care about your concerns, it's still meritorious to submit a comment, to submit a complaint, to submit a letter, because agencies do have obligations under the Administrative Procedure Act to take seriously information that's material to their decision making. And they can be on the hook if they don't take that information seriously. And even if, one particular administration doesn't really pay attention and care that much about your complaints, or that's your perspective on it or what have you, maybe a following administration will come in with a different perspective, and they can then say, look, under the last 5 years, we got 30 complaints on this issue. This is something we need to care about. So it's frustrating because, when you're in a problem situation, you want a resolution tomorrow or today. And sometimes participating in this process means you yourself might not get the relief that you want, but you're notifying the federal government of the existence of this kind of a problem, puts them on notice, and that can be significant and meaningful for down the line the way these issues get handled.
Yeah, right. Today's dissents can be tomorrow's precedents.
Right.
It's a good point.
Right.
I know we only have about 2 minutes, but one question I think might be worth a moment if you have it.
Sure.
So the various conscience protections that you mentioned, I guess basically why are they necessary if we have the Religious Freedom Restoration Act? Like, shouldn't that be a catch-all to protect religious exercise from federal laws that burden religious exercise?
Um, so there's a couple things. On the one hand, like we said, some of the conscience statutes are address moral beliefs in addition to religious beliefs, refer specific to religion. So it's a little narrower in that sense. I think, the courts tend to interpret what is religion broadly, but you could see some universe where the moral language can capture more, especially if you're talking about someone who just is completely irreligious. Um, the other thing is the RFRA really applies to federal government action. So when you're talking about, for example, a hospital, like one of the conscience statutes, the church amendments that are protecting individual doctors at the hospital's getting the Public Health Service Act funds, so they're obligated not to discriminate on the basis of conscience. RFRA is not necessarily going to reach that hospital. Even though they're getting federal dollars, they're not the federal government. So the federal government might be restricted in from discriminating against those providers or burdening their religious exercise, but you can't use RFRA to say you hospital are cannot discriminate against this specific doctor who works in your hospital on that basis either. So it has a broader, they have broader reach because they're following the money. They can touch more types of entities to create protections. And then, like I said, it creates some different affirmative protections as well.
Right. Great. Well, I know we're at time, so I know that was a lot of information. So for first of all, Gabriella, thank you so much for coming and providing this, and thanks for making your slides available. And if anybody's head is spinning but does want to ask a question subsequently, you can shoot me an email or the info account at Napa Legal if you don't have mine, and I'll send it along to Gabriella.
Yeah,
So
absolutely.
great.
Take
Thank
a
you all
moment
for
to
being here.
decompress and digest and then get back to us.
Right. Right. Thank you all.
Thanks, Frank.